was actually overturned, such that it cannot be law relied upon by this particular court. That's its decision. Your Honor, as I say so, we do pray that the court grants favorable bail and bond terms for the accused person. Your Honor, we have belabored the position that there are no two sets of laws. There is no law for a politician, a member of parliament, separate from law from the common knowledge. The Constitution is one. It applies to all of us, Your Honor. And the moment what the prosecution is actually advancing comes to play, Your Honor, it will mean that I, as an advocate, Your Honor, I'll have a different set of law if it is me on that particular dock. The same thing will happen even to the court. If one day a magistrate finds himself in that court, the same argument will be advanced. This person was a magistrate. Or even the DPP himself, or even Mr. Ondari himself. No one is immune from finding himself there. Your Honor, let the law apply to all of us equally, whether he's brown or black like him. It doesn't matter. I say that.
Your Honor, very quick reply. The defense is seeking to eat their cake and have it. They cannot submit that the integrity, the dignity of the accused person as a member of parliament need to be protected. And then make a 360 degrees turn and say, we are all equal and therefore should be treated the same. We are talking about influence. And not all of us have the same influence. And that's our point.
Yes, a minute. Yes.
Secondly, Your Honor,
yes.
The defense through Mr. Umbeta submits that we need not hear about witnesses because we have the Witness Protection Agency. It's like committing an offense, knowing, or cutting somebody a hand, knowing there is a hospital.
Yes.
I don't think that is the way justice is administered in this court. And then Mr. Umbeta submits that in the authorities we submitted about Marende, Jackson Marende, that in that case, which he admits, the accused person beat the witness. I agree with him. And I want him also to appreciate that in this case, the victim, who will be a witness, was shot, not even beaten, and critically injured. So it's in other words saying, where there is evidence that the accused person beat a witness, then the court will be justified to refuse bond. We have demonstrated that fact. Then, Your Honor,
with all due respect to my senior, Your Honor, we take great exception to that going on record without being charged, Your Honor. And you rightly told us, Your Honor, in this particular session, let us not just bring or rely on matters that we are bringing from the back. There's no evidence to that, Your Honor. He was not there when that was happening. Even the officer who was reformed was not even there. Those are
But we have a charge here, Council. We have a charge. The reason why I will not stop that is that we have a charge that says he unlawfully attempted to cause the death of Felix Odhiambo Orinda by shooting him on the neck. So he's just submitting on what is before the charge. This one is distinguished from the other facts I was talking about, because this one is based on the charge that is here. Of course, it is something that they need to prove, even at this level.
Your Honor, I'll be comfortable with that last sentence, but it's something they need to prove.
Yeah, of course, they need to prove the allegations.
Yes. We have attached the medical report to that.
Yes.
So it's not just a statement from the bar.
Yes.
Your Honor, there is then the presumption of innocence that the accused person is presumed innocent and therefore must be released on bond. Your Honor, on that, I think the statement of Honorable Justice Lesit in the matter of Republic versus Frederick Lediman answers sufficiently and succinctly. Your Honor, I invite you to look at paragraph 80 of that decision.
Yes.
Your Honor, the defense challenges the prosecution affidavit from the bar. Nothing has been put before this court by way of affidavit from either the accused person or any other person to challenge what the prosecution reports.
Your Honor, that is a new matter that counsel is bringing about.
There's nothing new, Your Honor.
It's new in the sense that the affidavit to oppose bail has just been served to us 3 minutes with the mischievous intention for them to get an adjournment.
The court
And they served us on
anybody
Friday.
from
Good and
seeking
fine.
time to file a reply.
Your Honor, you see
Never
that
sought time to file a reply and the court refused.
that is the position the state wanted, so that we ask for time to reply, so that the accused person continues to languish behind us. And the practice common here is that they serve us and will respond already.
Carry on. I'll not take that. I'll leave it at that. Yes.
Thank you, Your Honor. I wish to submit, and this is why we said the defense has been making spirited attempts to interfere with the witnesses for this case. Just now, Your Honor, you have been given payment into the Nairobi hospital towards the treatment of the victim in this case. What more interference will the court possibly be looking for than this? What more influence will the court be looking for than this? And then finally, the accused person through the defense counsel submit that the accused person has been in custody from 17th morning. And that he's the one even who paid this. It is not true. This document is dated 18th of January. It was a Saturday. And that's why we are saying it need not to be the accused person himself interfering with the case. He's a person of influence. He He has mechanisms and means to interfere with the case even when he is in custody. This is testimony. I rest my case.
So I've taken down the submissions from the prosecution and the defense. Of course, I've not considered them yet. But in all those submissions, there has been no mention of the views of the victim of the alleged offense as required under the Victims Protection Act. The court is of the view that given the gravity of the charges and the victim's views have to be taken into account before the court arrives at a fair decision on whether or not to release the accused person on bond. In the circumstances, I'll call for a bail report to be prepared by the probation department. The report shall contain the victim's views and may also contain other views from the accused person if he so wishes. The report to be filed in court within the next 7 days. The case will be mentioned on 27th of January 2020. For now, the accused person will be remanded in custody.
Yes. The victim has something to tell the court.
There?
The victim, the accused person.
I have said his views can be contained in the victim in the report that will be filed by the probation. Yes.
And secondly,
Yes.
We seek to make a review of the orders of 7 days. Then on the basis that the duration of 7 days is a very long duration, considering that the accused has been in custody for the last 4 days. Your Honor, the probation department, as a government agency well funded, is able to do that report in a day or 2 days. Your Honor, as practitioners in this court, we have seen them do that. We kindly urge the court to reduce the number of days to enable the accused to access a decision of whether he has been denied bail or whether he will get bail. Secondly, Your Honor, the accused was detained at Gegeri police station before he was arraigned before you. It is our humble prayer that he still be detained at the Giri police station pending him appearing before you. You know, this is based on the state's proposition that they want to monitor his access to witnesses, very critical, and that those are the witnesses, especially the victims, who are going to be covered in that report.
Sorry, I'm not following, Mr. Mari.
The state put it that he might interfere with the witnesses.
Remember, I've already made a decision.
I'm not challenging that.
Yes.
So, Your Honor, we are seeking that based on that fact, he be kept at the Giri police station, where the state is able to monitor his access and contacts with the witnesses. When we are amenable, if the court reduces the date, we can come any day, the earliest time possible, even in the afternoon, once the report is filed.
Your Honor, I find this application very strange, as it is interesting. My learned friend knows very well that this court cannot review its own orders. And even assuming the court had powers to review its own orders, the grounds purportedly fronted for review are very strange. One is that a probation report can be made in a day. And therefore it can come even tomorrow. And there is no reason given why. So the court has said 7 days. And then they make one interesting suggestion that the accused person be remanded in the Giri police station because he will interfere, we said he will interfere with witnesses. We said he be remanded in prison custody, remand custody, not police custody. In any case, Your Honor, witnesses don't live in industrial remand prison for him to interfere with them there. Your Honor made this order, thirdly, Your Honor made this order about 5 minutes ago. What has changed? To give them reason to apply for review of their own orders. Nothing. I urge the court to dismiss this application.
You know, we are not asking for a revision, which is not the preserve of this court. We are asking for a review based on the facts and evidence that we have produced before you, that probation officers' reports have been completed in a day. And the court can take judicial notice from what it deals with on day-to-day basis. Your Honor, it's true your pronouncements are 5 minutes old. It's no ground for us. It's is not ground to bar us or the accused to come to you again to seek the court's indulgence on a reduction of days. Or, if the court will be inclined not to grant our orders, we seek a mention date on Wednesday. If the report would have been filed, then there will be no need for 7 days. And I kindly, on that matter, we are seeking a mention date on Wednesday to be able to confirm whether the report has been done. Lastly, Your Honor, on the question of why Igiri Police Station and not the prison remand home remands, we have ably demonstrated that is a facility still contained and managed by the Kenya government, and there is no prejudice to location in the state. If indeed he is remanded at Igiri Police Station. Neither has the state demonstrated to you what harm it is likely to cause. May Your Honor grant our prayers, and we appear before you for mention date on Wednesday.
Now, the standard period for seeking a probation report, in this case a bail report, is 7 days. Of course, taking into account, as Counsel Mr. Omare has submitted, that the accused person should be able to access the decision on whether he is released on bond at the earliest. But the reports may come earlier or even later, depending on how fast the information sought is obtained. I have in the past, at least in one criminal case, number 1698 of 2018, had the decision of this court revised by the High Court on grounds that 7 days given to prepare the bail report in the circumstances of that case was not sufficient, and the probation officer had to be given more time to go and make a further report. Therefore, with the benefit of that hindsight counsel, then 7 days, according to this court, will be appropriate in the circumstances. In the present case, if the report is heard earlier, then either party is free to move the court for the same to be presented. After all, the decision whether or not to deny the accused person bond has not been made by the court. I have, however, not found good reason to have the accused person remanded at a police station rather than prison remand, and he'll therefore be remanded in prison remand.
Your Honor,
Yes.
before you say not
Yes.
Your Honor, there is an issue which is related to which we want the court to give guidance to. Your Honor, there is
Do I need to write, or you can explain
I
before
think
it?
it should even, it may be off the record in
Yes.
the past instance, because it's something our police have responded.
Yes.
Your Honor, there is a vehicle that belongs to the accused, which was impounded by the police. And Your Honor, that is the vehicle that the accused uses to take his children to school personally every morning. Your Honor, if there is they are not intending to use that particular vehicle, because it was just parked. Your Honor, that vehicle we would have wanted to make an application for it to be released and make it
Yes, before I take that, Mr. Ndari.
That one should not be a problem, Your Honor. It is not an exhibit, so they only need to say who should be handed over the vehicle.
Okay. So by let's say by 3, if the vehicle has not been handed over, then you come back to court so that we can save on this time instead of putting down the order and all that. But if by 3 there is any complication, you come back to court, we will review this and then you get the order. But it is from that is none other than the Deputy Director of Public Prosecution. He has given you his word that the vehicle is going to be released.
We only need to be told who is to be handed over.
The wife is here.
Are you confirming that that's your spouse and you like the vehicle handed over to her? We don't want to enter it. That's fine. Yes.
On the
a matter of paying the hospital bill, because it is because of that that the victim is still over their life. And it seems the state is not interested in the life of the victim. Should I proceed paying the hospital bill, or the list of treatment is not wrong?
No, I mean that's yours. I'll not get into it at this time. Thank you, Casus. I still have some other work to do, so we can ease the court so that I can carry on with taking plea.
Thank you.
Bye.